How many of you have a last will and testament or plans to create one? Well, did you know that the executor of your will may not be able to fulfill your wishes despite their best efforts? Many people assume that their last will and testament is the ultimate document dictating how their wealth is divided up. However, they are mistaken. In this video, I want to explore the crucial aspects of estate planning that often gets overlooked. After all, if you have saved, invested, and created some net worth for yourself, it's likely you want those assets to go where you intend, and sometimes, even more importantly, to prevent them from going where they shouldn't. Before jumping into the factors that can override your will, let's review the basics. A last will and testament is a legal document that communicates a person's final wishes concerning their assets. It provides explicit instructions regarding what to do with their possessions, whether they should go to another person, a group, or maybe they wish to donate them to charity. Typically, a will designates an executor to carry out your wishes, and it assigns your possessions to the beneficiaries listed in your will. It can also appoint guardians for children if they happen to be minors. On the other hand, what's called a beneficiary designation is for one specific asset. These designations apply to accounts and products, such as life insurance policies, annuities, individual brokerage accounts, and retirement accounts. And for many, that may be where much of their net worth is located. Wills are flexible documents, subject to the interpretation of probate courts, and can be contested by family members showing an interest in your estate, even if they are not mentioned in your will. Conversely, beneficiary designations with a financial institution creates an unimpeachable contract. The financial company and relevant laws ensure your designated beneficiaries receive the payment, even if other family members attempt to claim the benefit. One of the main differences between beneficiary designations and a will is that assets with designated beneficiaries can avoid probate, while assets included in a will do not. This is a huge advantage and a convenient way to leave an inheritance, since your loved ones can receive the money or assets without court involvement. Now, you might think the executor of your will is legally bound to fulfill the conditions you have outlined. But what if your wishes in your will conflict with the beneficiaries you may have listed years ago on some of your accounts? Well, in such cases, the executor cannot alter or violate the beneficiary designations on any financial products. Your will gets superseded. A beneficiary designation for a financial product takes precedence over your will in the event of any inconsistencies. When an individual passes away, the instructions in a will only distribute assets included in their probate estate. Assets with beneficiary designations get excluded from the estate by default. To avoid any conflict, it's critical to make sure that the language in your will correlates with each of your beneficiary designations. Oh, and let me take a moment to say I'd appreciate it if you hit the like button, subscribe, and I would enjoy hearing your comments below. Okay, let's continue. Beneficiaries can even be specified on local bank accounts, such as checking accounts and savings accounts. You simply need to request a transfer upon death and name a beneficiary for the funds. In some states, a transfer on death deed can also be added to land and other real estate to a designated beneficiary, allowing the transfer to avoid the hassle of the probate process. Other types of accounts where you can designate beneficiaries include life insurance policies, 401ks, 403bs, IRA accounts, individual investment accounts, and so on. Since all of these take precedence over a will, it's crucial to avoid common mistakes and the unforeseen errors within these institutions. It may have been years ago when some of these accounts were first created. Are you certain you know who you have listed everywhere? If you name person A as a designated beneficiary on one of these types of accounts, and your last will and testament names person B to receive the account, person A is going to get the money. The individual designated with a financial institution takes precedence over the person you named in your will. Another common mistake people make is leaving unintended beneficiaries on 401ks, IRAs, individual investment accounts, bank accounts, and so on. Anytime you experience a life event, such as a marriage, passing of a loved one, divorce, birth, or adoption of a child, you should review both the primary and contingent beneficiaries on your policies and investments. If you do not have a beneficiary listed on an account, then it will eventually become part of your estate. In that case, if a will clearly states what the wishes are for the account, then that comes into play. Without a will, then the probate process can drag out through the courts and the state will end up deciding what happens to the assets. You should also have contingent beneficiaries listed in the event that the primary beneficiaries pass away. For instance, if you and your spouse are both listed as beneficiaries on each other's accounts and both pass away in the same incident, having contingent beneficiaries becomes vital. Some financial accounts allow up to 10 primary beneficiaries and 10 contingent beneficiaries you can list. This enables you to allocate your assets precisely as you desire. For example, you could leave 50% to person A, 30% to person B, and 20% to person C. One other tip, in the event that your bank or other financial institution undergoes a merger or gets acquired by another institution, they usually transfer the assets and personal information without any problems. However, there have been cases where beneficiary designations were lost during the transfer. Thus, it's a good idea to check and ensure that your beneficiaries are still listed and up to date whenever there is a transfer or merger. Naturally, everyone should have a will, or some people prefer to set up a trust. But just keep in mind the importance of keeping your beneficiaries up to date on all of your financial accounts, because those designations trump your will, and they will determine who receives those assets. I hope this video has been a good reminder to keep your beneficiaries up to date on all your financial accounts. It's definitely one of those areas that we can easily forget about. As always, thank you for watching.